Mr. President, I would like to quote from the committee report. Quote, "The SRA supply data and the preponderance of the evidence presented to the committee indicate that there may have been an actual sugar shortage or at the very least anticipated sugar supply shortfalls prior to the issuance of Sugar Order Number 4. Close quote. May have been, or at the very least anticipated sugar supply shortfalls. Hindi pa po sigurado? The good sponsor cited the data from the SRA monitoring unit, and I agree that that data is the best evidence of a shortfall. But alam po kaya, Mr. President, ng good chairman, na various government agencies, hindi lang po SRA, were already flagging the sugar shortfall. Mr. President, is the chair aware that as early as April 8, 2022, the National Economic Development Authority already flagged the limited supply and the high prices of refined sugar and declared that domestic production of refined sugar is not enough to meet the local demand. Ito po ay nasa liham ni then-NEDA Secretary Karl Chua kay dating Finance Secretary Carlos Dominguez, dated April 8, 2022. This letter was in response to a request for comments on the letter of Coca-Cola, highlighting the company's supply gap of 116,000 metric tons, Mr. President.
So may we have the question?
Yes, Mr.
And
President.
if the pages referred to, averted to a while ago in the committee report, can we have that?
Mr. President,
Because
good
it's 75
chair.
pages.
Yes, I am referring to the quote from the committee report on the
Yes.
sugar supply data and the preponderance of the evidence presented to the committee prior to the issuance of Sugar Order Number 4, specifically, Mr. President, page 30. And as a counterpoint to that, and this is my first question, Mr. President, kung aware po yung good chair na in fact, as early as April 8, 2022, NEDA already flagged the limited supply. Ito po ay nasa liham ni dating NEDA Secretary Chua, dated April 8, 2022, addressed kay then Finance Secretary Dominguez, pointing out a 116,000 metric ton supply gap ng iisang kumpanya pa lang, ang Coca-Cola, Mr. President.
Yes, Mr. President, I affirm the contents of page 30 of the committee report, though I might not be aware of the letter addressed to Secretary Dominguez, which was not part of the committee report and was never discussed during the committee investigations, Mr. President.
Yes, Mr. President, good chair, and which I am bringing to the attention of this august chamber dahil ibig sabihin po, Abril pa lang, sa iisang kumpanya pa lang na Coca-Cola, meron na po silang hina-highlight na supply gap na 116,000 metric tons. At ito po ay pinansin na ng dating NEDA Secretary Chua sa kanilang sulat kay dating Finance Secretary Dominguez. Abril pa lamang po. 5 months before, Mr. President.
If the purpose of the good member of the minority is to put forward an official letter with a presumption of regularity after the submission of the committee report, we would note that in conjunction with what is contained in page 2 of the NEDA, likewise, which traces the prominent role of the sugar industry in the Philippine economic history. So all of this will have to be pieced together, and if the purpose of the gentle lady is to have this as part of the report, perhaps in the period of amendments, we can incorporate that if indeed the purpose is to establish that there was a sugar shortage, which the report affirmed that there indeed was a sugar shortage. It might be a surplusage, or it might corroborate existing documents made part of this report, Mr. President.
Mr. President, I thank the good chair sa kanilang sinabi na ino-note nila itong sulat pointing out 116,000 metric ton supply gap of just one company months before the events leading up to the sugar order number 4 noted earlier already by then serving government officials na inaasahan ko nga po pagdating sa period of amendments and even during the course of this period of interpellation na yung ganito pong mga nire-raise ko po nitong representation will indeed corroborate not only that there may have been a shortfall or that there was an anticipated shortfall, but that there was already an actually existing, hindi lang po probable or possible, pero actually existing supply shortage already.
That for matters of defense, it has to be brought in the proper forum. And to put this in the proper perspective, the role of the Blue Ribbon Committee is merely to recommend that a formal investigation be commenced by the Office of the Ombudsman or whatever appropriate body is there to investigate, and that the finding of guilt will only be made by a court of competent with competent authority and not the Blue Ribbon. So, if the question of the interpellator refers to the authority of the Blue Ribbon to find guilt, probably that's misplaced.
Yes, it would be misplaced, Mr. President, if that was my question. Pero hindi po yun ang tanong ko. I understand what the good chair has said, that it is the court who would make such a finding. Nga lamang po, this representation, bilang hindi po ako abogado, ay tinatanong ko lang po yung legal opinion ng good chair. Is good faith a defense in criminal, hindi sa harap ng Blue Ribbon, in criminal prosecutions for usurpation of official functions? Depensa po ba yung good faith or hindi po, Mr. Chair?
It can be used, Mr. President, as a defense, but then again, the act of usurpation of authority, again, I go back to the novel term I mentioned last night, refers to the act of knowingly and falsely representing oneself as an officer with an authority to sign. So, knowingly, that is the scienter. There is an intent, Mr. President. So, if you have a defense of good faith, you have to show that you signed that without that knowingly. So, how can you do that? When you sign, your affixation of the signature is a known positive act, an overt act of doing something to claim that position. I don't want to belabor that point, but if Yusek Sebastian or the other persons would want to utilize the defense of good faith, nothing will prevent them from so doing.
Salamat, Mr. President, good chair. Siyempre, kung knowingly at falsely minirepresent ang sarili, kontra doon yung good faith defense na sinabi naman po ng chair, it can be used. It can be used. And knowing that you don't have the authority, not knowing that you sign. So yung sapat na po sa akin, Mr. President, na sinabi ng chair na good faith can be used, as the good chair said, can be used as a defense in criminal prosecution. And like I said also earlier, Mr. President, good chair, I will not debate the factual question of whether or not Yusek Sebastian had criminal intent. Malinaw po sa aking isip, although others may of course disagree, that just taking all the circumstances together, the fact that there was a July 15, 2022 memorandum granting him authority to sign, the fact that there was no opposition from the executive to import 300,000 metric tons of sugar when it was first broached, and the fact that the SRA board is a collegial body and the signature of the DA secretary is actually technically not required to issue a sugar order, there is enough to sustain a finding of good faith. Ang mahalaga lang po talaga sa akin, Mr. President, ay nasabi po ng good share at nailagay po natin on the record that indeed, good faith is a defense in Article 177 of the revised Penal
Mr. President.
Yes, Mr. President.
Just point of order. Can we have that slide replaced, because people might misconstrue that as the one being acted upon. There's a slide posted here which has been there for the last 30 minutes or so, Mr. President. Thank you to the Secretariat. Mr. President, to clarify it once and for all. It can be a defense. However, when all the elements of the offense under Article 177 are present, good faith is negated. So there are 4 elements under 177. Offender may be a private or public officer. Pasok. Offender performs any act pertaining to a person, authority, or public officer of the Philippine government or any of its agencies or foreign government. Pasok. Number 3, offender performs the act under the pretense of public function. Hazy. Number 4, offender performs the act without being legally entitled to do so. Dito po sa number 4, siguro po kinulang yung 4th element, so good faith can be negated. Mr. President, ang dami po nating testigo noon, kabilang po yung dating executive secretary, na sinasabi naman niya, hindi naman talaga siya, bagamat nandun sa Memorandum 15, yung pagpirma niyang yon ay hindi siya inauthorize pa ng executive. Ganon din po yung perception ni na Mr. Serafica at ni na Mr. Valderrama at Attorney Beltran na ang akala nila ay authorized nga, kaya nagpirmahan din sila. So, the elements, all the elements should be present, but here we have element 3 and 4 which are on the borderline. So, good faith can be negated, Mr. President.
Mr. President, good sponsor. Well, I see the majority leader maybe approaching. But for the record, before this may be suspended for today, Mr. President, good sponsor, for the record, akala ko hindi po lilitisin tulad ng isang korte. Wag naman po sana po ang aking hiling, wag naman po sana nating sabihin na good faith can be negated. Minsan po, kapag po yung mga posibleng inosente ay inaakusahan ng mga krimen na posibleng hindi naman nila ginawa, minsan po, Mr. President, good faith na lang yung huling depensa nila. At wag naman po sana nating ipagkait yon sa kanila, dahil nga sabi ng good share din, Mr. President, hindi po tayo korte. Sapat na po sana iwan natin na good, yung sinabi po ng chair kanina na aking ipinagpapasalamat, na good faith can be used as a defense dito sa Article 177 ng revised Penal Code. As I said a few times, Mr. President, in the course of this initial interpellation, I'm not a lawyer, so I do not wish to belabor these legal points, but I do this because of a more critical point I'd like to make as an advocate for Filipino consumers and Filipino workers. This disproportionately punitive response by the executive against civil servants like Yusek Sebastian produces a chilling effect and discourages officials from acting with dispatch on issues as critical as prices and supply of important household commodities. At pag ganito po, Mr. President, ang talo po dito ang mamamayang Pilipino. Mr. President, good sponsor.
Mr. President, just a quick reaction that the element number 4 never came from me. It's part of People versus Uy, GR 248566, August 4, 2021, a decision of the Philippine Supreme Court, Mr. President. And as an additional reply, Mr. President, kaya nga po tayo nagbibigay ng ngipin sa pagbibigay ng rekomendasyon na mayroong maimbestigahan at parusahan para patunayan sa ating mga kababayan na hindi naman tayo nagiging lax sa ating oversight function at meron pa rin hong batas na dapat sundin. Kung lahat po ay tayo ay maaawa at patatawarin na lang natin lahat, ay wag na po tayong baka pumayag si Senator De La Rosa na dating Bucor, tanggalin na yung mga padlock sa piitan. Kung kaawaan na natin lahat. So, kailangan po yung dapat parusahan.
Mr. President, good sponsor, definitely hindi po awa ang pinag-uusapan natin dito. Ang pinag-uusapan po natin, katotohanan at kambal nun, hustisya. Mr. President.
Yes,
Thank you, Mr. President. It is a minority report, not a so-called minority report. Kahit pa i-annex nga siya sa committee report. The majority report will prevail. I guess in the end, Mr. President, the committee report will prevail as adopted or not by the plenary. And badges of good faith, Mr. President, good sponsor. With all due respect, the Supreme Court itself used the phrase badges of good faith in the September 2020 case of Madera versus Commission on Audit, in the October 2020 case of De Guzman versus Commission on Audit, and in the November 2020 case of SSS versus the Commission on Audit. Of course, Mr. President, these cases are quite new, so we should not fault the chair if he does not know of these new cases. Pero
I
wag
take
po
offense,
tayong...
Mr. President, to that attribution, Mr. President.
No, I apologize, Mr.
My lack
President.
of
No
knowledge
offense,
should not
ma'am.
be implicated here.
No,
I have a law exam on Tuesday.
Yes,
so I'm
Mr.
still a law student right now. Perhaps your staff are not the law students here.
Well,
so,
Mr. President, I am
move
not
that,
a lawyer
That
myself.
phrase should be deleted from the records, Mr. President.
I have no
If there
objection
is
to deleting,
If there is
Mr.
an
President.
incumbent law student here, I am the one. I am the
Miss-
one. I
May I ask
challenge
for 1
you.
minute
I
Whoever
apologize
is
to the good
whispering
chair.
you,
No offense,